In today's work environment, I think managers of criminal justice personnel are perhaps likely to discover that their employees are willing to file civil lawsuits not only against the organization but against other people in the public as well. Criminal justice employees can file lots of civil lawsuits. They may file intentional torts, which can include assault and battery. A battery occurs every time a law enforcement officer is spat upon, slapped, or is in any way the recipient of what might be deemed to be harmful physical conduct. The tort of assault refers to an attempted battery which places an individual in fear that a battery will occur. We know that criminal justice personnel are likely to be assaulted or battered carrying out the course of their 8-hour shift. Interestingly, criminal justice personnel can also file abuse of process suits. And this occurs whenever a criminal justice employee alleges that an individual wrongfully initiated an internal complaint against him. One of the caveats of this, of course, is that this could keep members of the public from filing complaints if they think they can be sued. Some courts will also allow employees to file abuse of process suits against their employers if the employers initiate internal complaints. This is a very interesting area of the law which is still being ironed out. Criminal justice employees can also file civil lawsuits alleging that their employer intentionally inflicted emotional distress upon them. However, these suits are almost always unsuccessful, and the employee would be better served to take alternate measures in order to try and collect rather than through this type of civil suit. Examples of conduct where plaintiffs have been unsuccessful at showing infliction of emotional distress include instances of racial discrimination, sexual harassment in the workplace, where the harassment has been patently offensive, as well as an instance where an employee was terminated based upon an unreliable drug test and the employer refused to give the name of the company that gave the unreliable drug test result. So clearly, infliction of emotional distress suits are unlikely to prevail in court. Therefore, we need not spend too much time discussing these and we can move on. Public service employees can also sue a third party whose negligence has resulted in an on-the-job injury. They may sue the third party for lost wages, medical expenses, compensatory and punitive damages, and collect other damages as well besides these. The firefighters rule, though, limits the public servant's ability to initiate successful civil suits against a third party. And the reasoning behind the firefighters rule is that the plaintiff assumes the risk of injuries by taking a job as a law enforcement officer or public servant in the first place. Therefore, under the reasoning of the firefighters rule, there can be no liability. Well, let's examine the firefighters rule in more detail. Let's suppose a police officer responds to a breaking and entering call during the very early morning at a nearby lounge. Now let us suppose that after entering the dark lounge, the officer is seriously wounded because he falls through an open trap door immediately behind the swinging doors of the lounge. One would think that if the officer is seriously injured, he might be able to successfully sue the owner of the lounge for negligence. After all, the lounge owner failed to maintain his workplace, which ultimately resulted in an injury. Nevertheless, using the rationale of the firefighters rule, courts have ruled that it is unreasonable to impose on landowners the obligation to keep their place of business in a condition where no injuries could occur to a firefighter or a law enforcement officer arriving at an unusual time of the day. Some courts have also justified the firefighters' rule by arguing that workers' compensation will cover any injury sustained by justice employees. The majority of states have adopted and still apply the firefighters' rule today. However, there is still a tremendous amount of debate as to whether or not a justice employee can successfully sue a third party for negligence which results in an on-the-job injury. Courts in Oregon, which include the Supreme Court of Oregon, as well as courts in Colorado, Pennsylvania, and South Carolina, have rejected the firefighters' rule. And the growing trend against the firefighters' rule has continued slowly but steadily. Also, I think it should be noted that the firefighters' rule does have numerous exceptions. For example, police officers are often permitted to initiate civil suits against drivers of motor vehicles who strike them while they were out of their cars. If a car strikes an officer while he or she is responding to a call for service, typically the officer may file a negligent civil lawsuit against the third party. Also, if the negligence is independent of the reason the officer was called to the scene, the firefighters' rule typically will not preclude the employee from filing a civil lawsuit. And if a third party is actively engaged in more than simple negligence and has failed to take precautions against an extremely hazardous situation, the firefighters' rule typically will not apply in this situation either. If an establishment repeatedly calls for service, this may invalidate the firefighters' rule as well. Let us suppose, for example, that there is a lounge owner who is negligent in allowing repeated excessive alcohol consumption at his place. If an officer sustains an injury by an intoxicated patron, most courts will waive the firefighters' rule, allowing the lounge owner to be sued for negligence by the officer, particularly if it can be shown that the owner of the lounge knowingly served an intoxicated person more alcohol. Also, the officer may be able to sue the intoxicated person for negligence in a civil court if he or she is injured during the lawful arrest. And when an officer is injured by an intoxicated driver of a motor vehicle, it is likely that the officer's claim will not be barred by the firefighters' rule. In short, if a third party engages in conduct that is willful or wanton, there is typically nothing that precludes a justice employee from suing this individual or establishment. Now, let's turn to defamation of character lawsuits filed by criminal justice personnel. A plaintiff may allege that he or she is the victim of either libel, which is a written form of defamation, or slander, which tends to be verbal. Usually, plaintiffs do not prevail in these defamation lawsuits, and this is probably because it is very hard for them to prove that there was malice. The term malice means that the individual who made the damaging statements either knew they were false or had a reckless disregard for the truth or falsity of these statements. Given this standard, it is difficult, if not impossible, to prove what someone's state of mind was when he or she made the statement in question. In addition to meeting the malice standard, plaintiffs also need to show that the statements made were being presented as factual. Generally speaking, if an individual presents an opinion, he or she will not be subject to a defamation of character lawsuit. Expressions of opinion are protected by the First Amendment. It is only when a statement is presented as being factual that someone can get into trouble, and even then it is unlikely that a civil lawsuit will prevail. Some states, by the decisions of the courts, have even adopted an absolute privilege bar to defamation actions brought by public servants. This essentially permits any citizen to make a comment about on-the-job conduct of a public employee to the employee's supervisor. Even if the citizen knows the statement is untrue, it is still considered to be privileged in some states. Interestingly, some states have enacted what are known as anti-SLAPP statutes. These have been designed to essentially prevent public employees from filing defamation suits against those who criticize their performance. Anti-SLAPP statutes, without question, are designed to inhibit criminal justice personnel as well as other public employees from filing suits against individuals who are critical and who have every right to be critical. They are intended primarily to dismiss meritless claims by the plaintiff, and therefore they're not believed to violate the employee's free speech. After all, if a claim has merit, then the employee may be free to file a defamation lawsuit. Let's suppose now that a police officer intends to use his taser gun or stun gun or pepper spray against an unruly person, only to have the device malfunction. Suppose that as a result of the malfunction, the officer is seriously injured. Can the employee sue the manufacturer under a product liability lawsuit? The answer is yes. Though criminal justice personnel have only recently begun to bring lawsuits against the manufacturer or distributor of products that have failed, there is nevertheless real liability. And it is worth pointing out that law enforcement agencies will often benefit any time an injured employee successfully sues a manufacturer or distributor for making or distributing defective equipment. Why is this? Well, after all, if a civil suit is successful and if the employee is indeed compensated by a manufacturer of criminal justice equipment, well, then it stands to reason that the employer will be able to recoup workers' compensation benefits, health insurance costs, as well as other payments the employer might have made to the officer resulting from the injury. So I would suspect that we will continue to see police officers sue manufacturers and distributors of defective products, especially when this results in a severe injury. And I think it'll be interesting to see how these claims play out in civil courts throughout the country in the years to come. Generally speaking, law enforcement employees have a difficult time suing their employers for negligence in a civil court, and this is because there is a workers' compensation remedy which is available. Even if the workers' compensation is inadequate or does not provide sufficient coverage, the employee will typically be unable to sue his or her place of employment. Perhaps this is why criminal justice personnel have begun suing third parties as well as the manufacturers of defective products. Of course, it is important to note that a criminal justice employee can still sue his or her employer under the Federal Civil Rights Act. Also, he or she may sue under state statutes which criminalize on-the-job discrimination or sexual harassment. And an employee can sue his or her employer or former employer for psychological injuries sustained on the job, which are typically not covered by workers' compensation laws. Some states have also passed legislation which provides criminal justice personnel with more opportunities to sue their employers. So if you are a manager of criminal justice personnel, expect to see civil lawsuits during the course of your career. These may come not only from members of the general public, but also from the very employees you supervise. This is something that the prudent administrator should be very cognizant and aware of.